And a very warm welcome to everyone here at Doughty Street Chambers and to those of you joining online. My name is Joe Middleton. I am chair of the Human Rights Lawyers Association, and it's my great pleasure to welcome you here to this evening's HRLA event, the Bill of Rights and the Enemies of the European Convention. As you'll recall, the Bill of Rights bill was introduced a year ago in June 2022 by the much lamented and departed Minister of Justice, Dominic Raab. A few weeks earlier, the government had indicated in the Queen's speech, I tried not to smile when I said that the bill was needed to end the abuse of the human rights framework and restore common sense to our justice system. Since then, progress of the bill has faltered, but the concerns it seeks to resolve are being addressed in other, no less striking ways. In short, the issues raised by the bill remain very topical. Edward and Maya will be discussing the bill and the developments since it was first introduced for about 45 minutes. There will then be an opportunity for questions, and if you're joining us online, please feel free to use a chat function for questions, or we'll bring you in live if you prefer that. And obviously, questions from the audience in-house also greatly appreciated. But to those of you who are here, please do help yourself to a drink if you haven't done so already, and stay on for a drink if you'd like to at the end, and for a chat. It'd be really nice to be able to speak to you afterwards. And if you're here, please turn your mobile phones to silent. Tonight's main speaker is Edward Fitzgerald KC. He is, without doubt, one of the greatest, most successful and creative human rights advocates of his generation, and he is a founding head of these chambers. Over a period of decades, Edward has fought for claimants and appellants in a huge number of the leading human rights cases in the UK courts, the Privy Council, in Strasbourg, and further afield. And what he has to say about replacing the Human Rights Act is uniquely informed by his own forensic experience and the cases he has fought in deploying the Act since it was adopted 25 years ago. We are also very pleased to have Maya Sikand KC here tonight. Maya is a member of Doughty Street Chambers, and she is a leading authority on the application of the Human Rights Act. She began her career as an advocate and a campaigner for women and girls in the NGO sector, but since joining the bar, she has carved out a niche practice in challenges to the state and the development of public law. So with those words, welcome to Edward and Maya, over to you.
Let's switch this thing on. Right, can you hear me okay? So I should begin by saying, Edward, it's an incredible privilege to be able to converse with you. Edward is, as some of you may know, is often referred to as the godfather of human rights, and that's probably right. Now, Edward, you have...
I think godfather's a bit sinister.
Edward, well, you have acted for some deeply unpopular individuals in keeping with the philosophy that human rights are universal. And I want to look at some of your more unpopular clients and ask whether those cases have contributed to the attacks on the Convention and the Human Rights Act, and whether some of those cases have led to some of the clauses in the Raab bill, and indeed possibly in the illegal migrants bill. Now, obviously, the Raab bill isn't the first time that there has been an attempt to attack the Convention or the Human Rights Act. Do you want to say something about the history of attacks before we dive into some of the cases you've been involved in?
Yeah, well, just briefly, there's been a long history of attacks on the Human Rights Act and indeed the Convention, and they really started with the Lifer cases in the 80s and 90s, where there was denunciation of the decision in Venables and Thompson, and in the decisions in favor of life sentence prisoners having reviews by the courts rather than the Home Secretary, and then having released by the parole board. So there were a series of attacks on that. And then also when Venables and Thompson got the anonymity orders, there was an outcry about them having anonymity for life and protection for life.
So I'm going to come to that.
Okay,
case.
I'll come to that. Well, right. Sorry. Okay, so
no, that's fine. I just maybe more generally tell us about the successive governments, different ways of attacking, and then we can get down to
okay. So
more
just
detail.
brief overview, so that you have those attacks. Then, with the war on terror, you get challenges to the Human Rights Act and to the House of Lords decisions in the A case, both to ban indefinite detention in Belmarsh and to ban the use of torture evidence in the courts. And then, those were the first decisions that prompted sort of outcry by Home Secretaries. You then get the July bombings, and Tony Blair makes his 12-point speech, "The rules of the game have changed," and the prohibition on deportation to countries that practice torture must end. He says the rules of the game are changing. Should legal obstacles to the deportation of terror suspects arise, we will legislate further, including, if necessary, amending the Human Rights Act. So that's Tony Blair in August 2005. And that led to a series of litigations, which fortunately the courts vindicated that you shouldn't deport to torture regimes. And then 5 years later, you get David Cameron on the attack with his misinterpretation and denunciation of the European Court's decision in the case of Hurst No. 2. That's giving the vote to prisoners. And he said, "It makes me physically sick even to contemplate having to give the vote to anyone who is in prison." And when people go to prison, they should lose their rights. And he again suggesting that if the European Court doesn't give way, they'll have to reconsider the position on the Human Rights Convention. And then Theresa May, 2016, I think at Conservative Party conference, denouncing the Article 8 decisions that gave convicted offenders and illegal immigrants protection from deportation on grounds of family life. That was the famous cat thing when she said deportation has even been stopped on grounds that someone had a cat. That's complete nonsense. The judge of first instance mentioned the cat once in his judgment. It didn't feature at all in the upper tribunal's decision, and it was only an illustration of the fact that there was a settled relationship. And then you get Chris Grayling calling for the introduction of a British Bill of Rights in 2015, and then it becomes part of the Conservative Party manifesto in 2019. So that's the broad history. And then with the government's criticisms leading to the Human Rights Bill, shall I just run through some of the key features of it, or would that be good, or shall I shut up?
No, shall we come to those when we look at the cases, and then we can come back to those clauses? So I was actually going to ask you to talk about Venables and Thompson, particularly in the context of the anonymity order and positive obligations, and how that may have led to a clause like Clause 5.2. But obviously people will may well know that Venables and Thompson were 10-year-olds who murdered.
Yeah. So that's the background. So the first wave of Venables and Thompson's decisions. Well, the first wave of Venables and Thompson's decisions was basically that the tariff, which had been fixed by Michael Howard on the basis of petitions from the Sun newspaper saying they should have life without parole, he fixed 15 years as a sort of compromise between the judges and the Sun, and said 15 years was the tariff. That was judicially reviewed successfully here, but then the European Court said the punitive period for HMP detainees, juveniles convicted of murder, should be fixed by the courts, not the Home Secretary. And then later that the post-punitive period, the release decision should be taken by the parole board, not the Home Secretary. So that was the first way. Of course, they're now trying to go back on that. There's a provision now in the Prisons Bill, which is saying that the final decision should not be with the parole board, but it should be subjected to appeal to the Home Secretary could reverse it, and then would have to be appealed to an upper tribunal, which would have to apply a test that respects the view of the Home Secretary. So that's sorry, the Minister of Justice. Who does it, yeah. So there's that in the Prisons Bill. The anonymity thing I think, was one of the reasons why they produced this clause 5 saying that you should disregard any positive obligations flowing from Articles 2, 3 and 8. And that was because of, basically, they wanted to attack the Osmond decision, putting the onus on the police to protect people who whose lives were threatened. And they were saying this is too big a burden on the police. And the decision in Venables and Thompson, the contra mundum injunction, giving them lifelong anonymity and lifelong protection, that was also a target of the new clause 5.2. And what they were basically saying is there's nothing about positive obligations in the European Convention. They've all been invented by European court judges since, and it was going back to a kind of originalist interpretation of the European Convention, that since they don't spell out any positive obligations in the original text, there should not be an inference of a positive obligation from Article 2, Article 3 or Article 8. So that would have been a radical overhaul of how we've understood the Human Rights Convention and the Human Rights Act.
And the clause, I think the way it's drafted was to say no new obligations should be
yes.
There shouldn't be an incremental development.
That's right.
But also that there should be a sort of limit on the enforcement of those rights with a view to policing resources.
Yes, you had to have regard. So if you say if someone gets an Osmond warning and it involves a lot of police resources, the court should say, well, maybe this is disproportionate to devote police resources to it. And of course, similar things would apply to Venables and Thompson, whose lives were threatened repeatedly, having new identities, having protection. That obviously involved police resources. And they were saying that in deciding whether to grant one of these injunctions, you had to have regard to the resource implications of granting them. And it was obviously intended to deter the courts from granting anonymity orders.
But sort of positive obligations have become so important to the work that we all do. For example, cases such as DSD, which came out of the War Boys litigation.
That attack on positive, as you say, would affect decisions like DSD, which was based on the duty of the police to investigate properly and prevent the rapes that he committed. And so those kind of cases, they're clearly saying they were clearly saying we should put an end to them. We don't know really what's going to happen to the RAG proposals, but what it looks like is chunks of them are going to be taken out and reappear in other legislation, such as the removal of Rule 39 has now reappeared in the new bill as in the illegal migration bill as clause 53.
Yes, and we'll talk about that in a moment. But even if clause 5.2 has died a death with Rob, let's hope so. There is it's a very worrying aspect of the bill. Not just, although it appears to suggest that the positive obligations as they currently stand would remain. The idea that you can't keep developing those, for example, I imagine they had in mind developing the sort of Article 8 positive obligation and then curtailing them. So although there isn't, through the sort of government eyes, you had very unpopular clients, albeit they were children who are usually, deserving victims. But the law has moved on to protect women, children, gender-based violence, and those duties are now a really important part of our jurisprudence. The idea that they could be watered down or revoked is terrifying. So.
Yes, I agree. No, I agree. I think that it was a general attack on positive obligations on the basis that they put an undue burden on the police who should be catching criminals rather than protecting people.
Yes.
I think that was the idea.
Yes, and I think we'll see more of that in some other bill. So I wanted to talk about prisoners and their right to vote. You mentioned David Cameron wanting to throw up.
Yes.
And God knows we all have our own vomiting thoughts about David Cameron, but he Hearst number 2 is what he was eventually really complaining about. Now, although you yourself didn't do Hearst number 2, you were involved in Hearst in the domestic courts,
yes, yes.
But the important thing about Hearst number 2 was it was a challenge to the sort of blanket ban on prisoners voting, not this kind of Cameron approach that convicted murderers would now have the right to vote.
Yes, I mean, it was a real setup that the decision in Hearst number 2 never said murderers have the right to vote. It simply said you can't have a complete blanket ban on all prisoners voting, and it followed a case of the Canadian Supreme Court, which said a blanket ban on all prisoners voting would be unconstitutional, but it would be okay if you limited the vote to those, you excluded those convicted of violence and serving long-term sentences from the vote. That was Sauvé number 2 in Canada. And I think the Canadian Supreme Court then went further and said, actually, you had to justify any denial of the vote. But what the European Court said was simply you can't have a complete blanket ban on all prisoners voting because it was arbitrary. And for example, if you're in for 3 months for not paying a bill or something like that, you shouldn't be excluded from the vote. I think what happened there was that the Tories were determined to have a fight on this and to present it as this means that murderers will have a vote. And they never engaged with the European Court or Council of Ministers for some form of compromise, although there were people like Dominic Grieve who were working towards some kind of compromise. Finally, I mean, after about 10 years of this demonization of the European Court for giving the vote to murderers, they compromised if you were conditionally released and subject to a short sentence, you could have the vote, and the European Council of Ministers rather cravenly gave in and said, okay, that will do. It's not a blanket ban. But I think that shows that they were spoiling for a fight, not really looking for a solution. And that kind of thing seems to be repeating itself now with the Rule 39 provisions, the effectively interim measures. But it could easily have been solved right at the start with a very limited measure along the lines of the first Canadian Supreme Court decision. This collision was wholly unnecessary. And the criticisms of the European Court were just based on a misreading of the judgment.
A deliberate misreading.
Yes, I think that's right. I mean, it was misrepresented, and the certain wise attorney generals knew very well what could be done, I think, and would have wished that to be done.
That's because there were suggestions by the European Court that it could be perhaps prisoners convicted of non-violent offences, under 4 years, short-term sentences.
2 years.
There were, but it took them years and years and years and years to finally come up with that compromise. So it's difficult to understand how that could possibly justify clause 7, which I think is generally the clause which says prisoners have been given too many rights.
Basically, yeah. I mean, there was also this idea that you shouldn't be giving damages to prisoners. Yes, it says well, clause 7 said deference to decisions of Parliament before declarations of incompatibility are made. Would already, and that was undoubtedly with the vote to prisoners in mind. And then they had the clause 18(5), which basically said you had to have regard to the fact that the people were prisoners in making any rulings. The philosophy being that you shouldn't give orders of damages to prisoners because they were convicted of crime and therefore didn't deserve damages. So I mean, that was a pretty radical provision, 18(5). But that hopefully that one's bit the dust, although some of it may resurface in the prisoners' bill. Yeah.
And so looking at, well, sort of looking back, before we get to the horribly named illegal migrants bill, I thought we could look at one of your, probably your most unpopular client, Abu Qatada.
Abu Qatada, yeah.
I think it's fair to say it's probably your most unpopular, although it's difficult to choose.
Abu Qatada was a very well. I mean, one has to remember he was never convicted of any crime, and indeed, in the end, he was acquitted when he went back to Jordan. But it was a long battle before that. But I mean, the thing about Abu Qatada's decision was it was always given as an example of the lunacy of the European Court. And the two issues the European Court considered was, one, should the Jordanian assurances that they wouldn't torture him be accepted? And there was strong arguments that given their systemic use of torture, you shouldn't accept their assurances. And many, fine dicta from the Canadian Supreme Court along those lines. The European Court actually said that we should accept the assurances of the Jordanian regime and accepted the argument that there'd been a long friendly relationship between the UK and Jordan, and that they wouldn't breach their promises not to torture him, and that therefore you could accept the assurance that he wouldn't be tortured. The thing that the European Court ruled in his favour on was that there was really very powerful evidence that his two co-defendants had been tortured into making confessions which incriminated him, and there was clear evidence that those confessions obtained by torture would be used against him at his trial. And so they simply said that it would violate Article 6, it would be a flagrant denial of justice, if he went back to Jordan and was tried on the basis of convictions obtained by torture. And so that was the Article 6 ruling. Eventually, it came back, and after going to the High Court again and then to the Court of Appeal again, Theresa May accepted that principle and negotiated a treaty with Jordan saying we will not, the Jordanians saying we will not rely on the torture evidence. So he then agreed to go back voluntarily. They kept their promise not to use the torture evidence, and there was no evidence against him, so he was released. And now it seems to me that's a classic example of an entirely reasonable decision of the European Court in accordance with international law, which cannot be described as lunacy or departure from all established norms, just held us to not deporting to be tried by torture. And in fact, it led to him having a trial without any torture and being acquitted. So, I mean, it actually is an example of the system working rather than it not being able to work. The problem was it took so long to reach that decision. But the European Court comes out of that, seems to me, extremely moderate and standing by a pretty fundamental principle that you don't use torture to convict someone.
And yet, though, Edward, it's cited as often as a reason for pulling out of the convention.
Yes, I mean, it is. I mean, the reasons they give are the vote for prisoners, which is easily answered, the Abu Qatada case, which I hope I've answered now, and then the cat. But that was the English tribunal, not the European Court, and there's a misinterpretation of that. The cat, I think, is that what's the other one that they? I think those are the two. Those are the three big ones. Yeah, the right to vote. Abu Qatada. There's also the thing about long delays, and I suppose Rule 39 is the other issue.
Yes. So I'm just looking at. I think the sort of Abu Qatada clause is clause 20 of the of the bill.
Yeah, that's an extraordinary provision because they basically say that where the Secretary of State says, if you go back, you will get a fair trial in some foreign jurisdiction, their decision is final. So that was, I'm just trying to find, is it 20? No, is it 20?
20.
Clause 20, yeah. Yeah, clause 20 basically said that if you are going back for a trial in a foreign state, the Secretary of State's decision that you will get a fair trial is unappealable, or the courts must accept it. So I mean, that was an extraordinary thing, which would have reversed, obviously, Abu Qatada, and would have meant that the English courts couldn't say, which they did when it came back to them, well, he won't get a fair trial because it'd be based on torture.
So any assurance made by a foreign state would be a matter for this state to accept, and the court would be prohibited from intervening.
That was only on Article 6, though. It was only on Article 6, but it was undoubtedly intended to address the Abu Qatada decision.
You said something about cats and Article 8, and what is the Article 8 problem through the eyes of the government? Is there any basis? Are they, leaving aside the cat, which is obviously ridiculous, but what is the Article 8 concern, which finds itself, I think, expressed in clause.
It is clause 8. Clause 8 of the bill was basically to say that you should only be protected from deportation if you could show manifest and extreme harm. I mean, so they wanted.
So the interference
with family
life has to show manifest and extreme harm.
Yes. And
so it's a rewriting of Article 8.
Yes, it means you wouldn't do the balancing.
You wouldn't do the balancing.
Yeah, you wouldn't do the balancing of family life against the damage, and so foreign offenders would not be able to fight off deportation, for example, on grounds of their family life. And the government, in justifying this in the white paper, referred to two cases. One was of someone whom they described as a Nigerian national, who was in fact born in the UK and brought up here and knew only the United Kingdom. And that was a case where he had been convicted and sentenced, I think, for a substantial period of time. But he was able to say effectively, I've lived in the UK all my life, all my links are here. It would destroy any family life I have if I was deported. And then there was a Turkish national convicted of grievous bodily harm when he was aged 24, and he married a British national, brought up a child as his own, alongside their 2 British children, and they had 5 British grandchildren together. I mean, he was fully integrated into UK life. And so this idea of saying foreign nationals were being protected effectively, both the examples that they gave were of people who basically were totally integrated into life here. And the effect on their family life would have been devastating, but probably would not have satisfied the test of extreme harm.
Extreme and manifest harm, but also
yeah.
Having to put the greatest possible weight on the public interest.
Yes. Yes, that's.
So it's a complete rewriting of proportionality, balancing. In fact, it's not really Article 8 anymore, as we understand it.
No, that's right. That's absolutely right. I mean, it was an extraordinary bill. I mean, there's a whole load more one could go into, but it, gets rid of positive obligations or waters them down, rewrites Article 8, destroys any Article 6 protection for the future, and then it's full of stuff about deference to the will of Parliament.
Yes.
And then, of course, there's also the final provision, which is that any Rule 39. The provision there was that any Rule 39 indication from the European Court, i.e. interim measures, should be disregarded by the courts.
So that was, shall we talk about that? But that was clause 24 of that bill, wasn't it? So interim measures by the European Court. So Rule 39 was recently used effectively in the Rwanda litigation, which has meant it's the government's concern about Rule 39 has found its way into the illegal migrants bill.
Yes.
Not in a outright sort of ousting of it, but in a slightly more subtle but terribly worrying way.
That's right. I mean, so you had clause 24, which said disregard any Rule 39 indication, or the courts must disregard them.
Yes, which is a sort of outright.
And then you get the new Illegal Migrants Act, and that's, I think we've got it here. Bill. It's so it's clause 52 and 53, and clause 53 of the Illegal Migrants Bill says that this section applies where the European Court of Human Rights indicates an interim measure in proceedings. So that's what had happened in the Rwanda case, that they had given Rule 39 protection to someone who said he was a victim of torture and was about to be deported. And it says, a minister of the Crown may, but need not, determine that the duty in section 2.1 is not to apply in relation to the person. So a minister of the Crown can just say, I'm not going to follow the Rule 39 order.
No, it's a duty to make removals, isn't it?
The duty to make removal remains, and the minister can say that I won't apply the duty, or I will apply the duty according to what he feels. And then there's a whole series of tests which are set out at subclause 5 as to whether the minister will decide to disapply the duty to remove. And those are whether the government of the United Kingdom was given an opportunity to present observations and information before the interim measure was indicated, the form of the decision to indicate the interim measure, C, whether the European Court of Human Rights will take account of any representations made to it to reach a decision without delay, and D, the likely duration of the interim measure. And it's been described as legislation or negotiation by legislation. In other words, what they want to do is to go to the European Court and say, we've passed this bill, we will disregard Rule 39 measures unless
you give us a voice.
you one, hear representations from us before giving Rule 39.
Which is not currently how it works.
Yeah, which actually, I think that's not unreasonable to say that should happen. But two, the form that it shouldn't go on for years. It should be reviewable, and then I think that then the hearing should take place swiftly, I suppose is what they're going to say. Now, it seems to. I think Maya and I have discussed it, that they could have just simply gone to the European Court and negotiated with them, saying, we've always respected your Rule 39 indications, unlike Russia in the Mamatklov case. We've always respected them, but there must be a mechanism by which we can be heard, either before an interim measure is given or after it with a view to its revision. And you probably should provide an appeal mechanism for when the interim measure, which I think is applied by one judge, single judge. I see nods from Joe and Maya, so I've got that right. So single judge gives it, maybe on the papers quite quickly, and then the interim measure may be maintained for some years. So there is, I think one has to accept that there is a legitimate case for some review of the procedure. But to say you disregard it unless is kind of unilateral, putting the gun to the head of the European Court. So whilst there is a case for some reform on the part of the European Court of the way in which they give and maintain Rule 39 measures, this is simply a license to disregard Rule 39 measures, which would be a breach of international law. So I think it's interesting that it's much more moderate.
It is.
Than so clause 53 is much more moderate than the old clause in the Dominic Raab bill.
Given that it's Suella's bill.
Yeah, it is. I think it's still sinister in the sense that it does legitimate disregarding a Rule 39 measure. But well, I don't know, maybe other people have different views about it, but it seems to me that there is probably a case for reform of the Rule 39 procedure.
Well, one of the things is whilst this toing and froing is going on between the government and the European Court on the Rule 39 itself, what happens to the person subject to deport? Would there be status quo then, whilst the Rule 39 argument is being played out? The whole point of Rule 39 was to stop the deportation in the first place.
And in fact, in this case, the one that was granted in the Rwandan case, the guy won in the end. I mean, it's just as well they did give a Rule 39 indication, because if he'd been put on the plane and deported before there'd been a proper consideration of his case, all the flaws in the original decision would not have been exposed. So I think one can.
He'd also been the only person in Rwanda from here.
I mean, the policy is ludicrous. The legislation specifically intended to protect it is sort of totemic, really. But I think it will be a subject of debate. I gather there's Geoffrey Robertson, unfortunately left, but drew attention to the fact there's been some articles by some Oxford law professor this morning, and I think Jonathan Sumption, saying that actually they don't think that Rule 39 has the force of law, of international law anyway. So there's a big debate about it, but there's pretty clear ruling in the case of Mamakloff that Article 34 and the duty to cooperate with the European Court does involve an obligation to follow Rule 39 indications, and the UNHCR has made similar rulings. I mean, it's a kind of article of faith that when you get an indication of this sort, to hold the status quo pending the consideration of the case, the interim measure should be abided by.
Do you know, Edward, has any other contracting state taken a view about the Rule 39 procedure and being allowed to, have a proper voice in the process?
I don't know. I think the policy followed by some states is just to disregard them and take the. I mean, Russia did that when Mamakloff.
Yes.
And I think the French used to have this. I better not libel the French, but I think they did have a policy of saying you will have a non-suspensive appeal. In other words, you'll go abroad and you can appeal about the deportation, have your case heard later. But I think no, I don't know of any other case other than the Russian.
Yes. So
we're in rather bad company.
Yeah. Yes. But that's very much on the table, and we're watching this drama unfold as we speak. I just wondered whether anybody else had any views or about Rule 39, or in fact about any aspect of the issues Edward and I have been talking about, or a question for Edward. This is your moment.
Hi.
Thanks so much. Hi, I'm Connor. I'm a barrister at 5 Essex Court. I was really interested in what you were saying about Tony Blair, because I think we often think, the Tony Blair government, introduced the HRLA and, it's all very good. But actually, you've reminded me it wasn't quite so easy. And can I ask you perhaps to just expand on that a little, if you would, and also to gaze into your crystal ball and to think about, we've got an idea of where the Conservatives would go. What about Labour, Starmer? I mean, it's difficult perhaps to see, if I can put it in that way. And also a sort of broader question, which is, how do we try and get the public to actually understand the value of human rights? Because I often find at these kinds of events, and it's not a criticism, of course, but, we've got lawyers or law students all talking with one another about the virtues of human rights, but actually conveying that to the public is a quite different task.
I think that's
Thank
a
you.
very, very good point. Well, I'll try and answer the historic question. I mean, there's no doubt that some of the, or some exceedingly illiberal measures were introduced by the Labour government with Blair and Blunkett. I mean, I think it was they who introduced the preventative detention orders, which we've been living with the residue of for many years. The life effect, indefinite detention of sexual and violent offenders.
Well, IPP.
IPPs,
That was their great
that was their
contribution
thing.
to
Yeah,
the
and that
prisoner state.
led to a massive of 10,000 people, I think, in all. So there was that, and then I mean what happened after the 12-point speech was that they started to deport people to try to deport people to Libya, Algeria, Egypt, who would face torture there on the basis of assurances that they wouldn't be tortured. Now, whatever the position is in Jordan, to send someone back to Gaddafi's Libya on his promise that they wouldn't be tortured was madness, and it was a ridiculous policy. And fortunately, the English courts, in a series of decisions, quashed the decision. But Blair was dead set on deporting to Libya, the members of the opposition party there, many of whom are now members of the government of Libya, who opposed Gaddafi, who was, without a doubt, a murderous psychopath. I mean, he hanged 400 students in one day. He was, I mean, the idea that he was going to respect human rights was frankly ludicrous. And so, yeah, I think some of the worst excesses were committed under the Labour government. But looking forward, I have every confidence that our former colleague and human rights champion, Keir Starmer, will not stand for any of that. I think being realistic, I mean, nothing of that order, of that kind of crass sort of madness would be. I mean, that doesn't mean that there may not be particular legislative proposals that we as human rights lawyers wouldn't want to criticise. I don't know. I mean, they haven't given us enough details yet, but we'll see. So, what do you think?
This kind of crass Bill of Rights bill could never be something that Keir would author or support, or his government. But as to whether Labour is going to restore rights that have been taken away, not just by this government, but previous Labour governments, well, that's very difficult because, as we all know, once rights are taken away, it's impossible. It's difficult, if not impossible, to get them back. So, yes, I would. I think I can say with some conviction that the Human Rights Act would be safe under a government led by Keir, but we have to focus on what's going on now and what the current Home Secretary is trying to get through to Parliament, and then undoing that mess would be a great challenge for any new Labour leadership.
And then your wider point was, how do we sell human rights and the conventions? Yes, because I mean, I think the original idea was, I mean, again, Dominic Grieve used to say in public presentations that the problem with the Human Rights Act was that the British people don't warm to it. It's not like a constitution. And I think that really is a matter of getting out there and championing it. I mean, obviously, Liberty tries to do it, Justice tries to do it, but it is a question of pointing out, that, for example, as Maya says, that the positive rights have been led to increased protection of women and children, and that they are something additional that the European Convention being incorporated has added to our protection of people in need of protection. So I think there are, there is a case to be made. Not just for the unpopular, but for ordinary people. So
yes, so those of us, for example, who do a lot of inquest work, without Osmond and without Middleton and without there being acceptance of a positive Article 8 duty, we could never have had the investigative duty, which itself is parasitic on potential breaches of the operational and general systems duty. And those are fantastic protections for ordinary people who lose their loved ones at the hands of the state, or potentially at the hands of the states. I mean, at the time when there was a serious proposal to scrap the Human Rights Act before this bill, or maybe at the time, there was a massive campaign by the likes of Liberty and Justice and other, which was focusing on just ordinary people and how the Act protected them, whether it was in the context of legal aid or an inquest or a family life. So the focus isn't just on, foreign national prisoners. But I suppose we have a duty to correct the disinformation, as Edward's tried to show throughout. Like, Hurst wasn't about. There was no part of any European court jurisprudence that at any stage said all prisoners must have the right to vote, but that is the way in which it was characterized. And we live in a world now of very fake news and the spread of disinformation. So I suppose it's the duty is on all of us, yes, as lawyers, but yeah, I don't.
Yeah, I think freedom of speech too. I mean, there are some, Sunday Times case and things like that. Have been really important. And no, but the inquest example is one we live with day in, day out. I think there is a massive case to be put, a positive case for the European Convention. I mean, the European Convention also restricts sort of executive power and tends to judicialize things, which I suppose we as lawyers think is a good thing. But I think it generally is a good thing, because it means you have a process, you have a hearing, you have an open, transparent hearing at which things are decided. And even though tariffs have probably gone up, the idea that they should be determined in open court with an opportunity to make representations and appeal rather than being decided by the Home Secretary behind doors is a positive thing. And so there's a lot of reforms that were introduced as a result of European Court decisions, which have been positive, and really nobody would really criticize the idea that there's got to be a separation of powers now. We accept it. But at one stage, the Home Secretary was saying, no, this is my decision. I'll decide how long a lifer does and when they get out. And that quite clearly was wrong in principle. Yeah.
Anybody else have a question?
So thank you for the talk so far. My name is Sunny Singh. I've just finished my 3rd year of law.
Oh, wow.
I have 2 questions mainly. I think one you earlier brought up about Rule 39 and how there might be a case, especially with how the ECHR, the courts at least don't hear representations from the member states before making the decision. But I mean, given every other kind of clause in there, especially about how there's a permission stage, which kind of filters out a lot of important cases, and also about how public authorities no longer have to, sorry, can you hear me?
No, I can hear it now.
Yeah, and how public authorities may no longer have to, really abide by the human rights, or abide by certain ECHR clause rights. Do you really think the Conservatives have put this forward as a case of good, put this bill forward in good faith, or do you think there is something else going on as well? And a second question is, I mean, regardless of what
you mean the Raab bill or the new one?
The Bill of Rights bill.
The illegal migrants bill.
It looks like they're going to give up on that.
Okay.
So I think it looks like with Raab going, the momentum to introduce the Bill of Rights has been lost. So I don't think the proposed Bill of Rights now will go through.
It hasn't had a second reading.
So I think it's died. So it's an indication of what their thinking was. But what I think is happening is that some of the ideas there, some of the clauses there, are being put into other bills, like the prisoners bill has got the bit about the Home Secretary being able to overrule the parole board. The Rule 39 thing has come up in the illegal migrants bill. So, but I'd be surprised if they had another frontal attack with the human rights bill. I think it's probably died a death with Dominic Raab for the moment. Yeah, but I think he probably passionately believed that he was right in doing it, but it's just we just totally disagree with his beliefs, you know. You know, there are politicians who think that the courts have no business interfering with Parliament's will. That's really it. That's the debate, I think.
Yes, so I think we'll still see the debate about Section 3 and
yes, yes. I mean, we didn't deal with that, but one of the things they didn't like was the interpretation, the creative interpretation and development of the protections of the article and the interpretation of English legislation in the light of convention powers. So they wanted to water down Section 3 of the Human Rights Act,
which itself was a compromise.
Yeah, which is yes, yeah,
you know,
yeah. So the whole process of progressive interpretation, that it was a speaking document, an evolving standards of decency, a living tree, as it were. They hated that. They wanted to go back to this idea of, well, what did the founders of the European Convention mean in 1950 when they signed it, and it shouldn't expand beyond that. That was very much the underlying philosophy.
Actually,
Sorry.
oh no, did you have another question?
I had
Go
like
ahead.
a follow-up, I think might be related as well.
Sure.
So, I mean, hopefully with this Bill of Rights, bill die down as well. But even with the other bills that come out, do you think like the current common law could still somehow protect, you know, whatever rights we already have, or do you think that will also go away with the new clauses? Thank you.
Well, there is always sort of the common law for some things. I agree, and you know, a case like Osborne suggests that you can do
fairness.
you can do more with the common law sometimes than with Article 5.4. But I think that we would lose an awful lot if the European Convention were not incorporated. And the ridiculous thing is, if you're still bound by the European Convention, still bound by the decisions of the European Court, to not domesticate it is actually to just delay remedy indefinitely. Because I mean, sometimes the cases that we took to the European Court took 5, 6, 7, even 10 years to get there. So the idea that you can't get into court and actually make the right real in a timely manner is a massive it's a massive thing, and that's why the Human Rights Act was so important, really.
Actually, I wanted to ask you, Edward, have you got that bill there, the illegal migrants bill?
Oh yes, I have. Yes,
I wanted to ask you about, because
God,
we're talking about Parliament being consistent with the Human Rights Act. I wanted to ask you about this bit right at the outset.
I think we'll ask Joe. Joe is the great authority on immigration
this,
law.
You see, this I am unable to make a statement that, in my view, the provisions of the illegal migration bill are compatible with convention rights, but the government nevertheless wishes the House to proceed with the bill. Has this ever happened before?
No, I don't think it ever has. No, I mean, obviously there's been derogation in the Belmarsh detention in the leading to A, but no, there's never. I don't think there's ever been that.
Well, exactly.
So it's a pretty extraordinary thing. Yeah, it's a pretty extraordinary. Yes, I mean, where they're bound by it, and they're saying we're going to act inconsistently with it, even though we're bound by it. I mean, presumably they had advice from their lawyers saying, well, you just can't do this consistently with the human rights.
Right, but then what would happen if you try if you bring litigation and then you try to use Section 3 because it isn't compatible in the first place?
I see. You mean for interpretation?
Yes.
Well, I suppose one could say this is an admission of guilt. Yes, I mean, it is pretty extraordinary. I am unable to make a statement, in my view, the provisions of the illegal migration bill are compatible with the convention rights. but the government nevertheless wishes the House to proceed with the bill. I mean, it's no, you're quite right. That's the most important part. And I didn't even mention it. I mean, it's an extraordinary provision.
But what does that mean for, in terms of the rule of
Well, I
law
mean,
and constitutional rights?
I suppose you could ask for discovery and interrogatories as to which parts of the bill do you admit are inconsistent with the convention rights. Please give us full details. But I mean, it's a stunning admission. I don't think it's ever happened before.
No,
I mean, there were cases of derogation, but then the European Convention allows for derogation.
derogation.
Yeah.
I mean, but to have a bill in the 21st century, given that this is our constitution, to say it's actually actively inconsistent with it.
Yes, no, that's a really important point. Yeah.
I don't know where it leaves us.
Yeah. Sorry, is it? Did someone else want to ask a question? Oh, no, sorry. Any views on the? Oh yes, here we go. Yes, go. Yeah.
There's no questions on the Q&A, is there? There's no questions on the Q&A, is there? No. Good. What was I going to say? Yes. So common law, just returning to the theme that you were talking about, which I think is an interesting one. I'm interested in this idea that the courts have had about to what degree Parliament can take away, by implication, common law rights. And I just wondered if you could maybe explain that a little bit. As I understand it, the general rule is Parliament can't sort of impliedly repeal common law rights. But I think there's a comment from Lord Bingham, which basically says, but it all depends on statutory interpretation and context. And I'm just wondering how that plays out, because it seems to me that if, as suggested, the HRA is repealed and the worst happens, we may have to revert back to sorting out those sorts of issues in a more earnest way.
Yes, well, I mean, what's interesting is just before the convention came into force with the Human Rights Act, in cases like Sims and O'Brien and ex parte Pearson, they were already developing this concept of legality as an interpretive principle. So they were already kind of pushing the common law, saying that unless they very expressly took away a right, they would imply it. That was, the right of access of a prisoner to a journalist was not provided for at common law, and they, you could, but they just said, well, it's part of free speech, and unless the Act actually expressly, i.e., an Act of Parliament expressly authorised the taking away of the right of access to a journalist by a prisoner, that would be it would be unlawful, a standing order that said you have to get permission. I mean, that was an extraordinary judgment. I mean, the American constitutional decisions refused to confer a right on prisoners of access to journalists. So the English courts, by reference to kind of common law principles, created this right to go to a journalist and complain about your miscarriage of justice, which other supposedly more sophisticated constitutional regimes didn't even recognize. So I think, there was a lot we could have done, and could still do if we had to go back to the common law. And the other interesting question is, would it be the common law as enriched by convention principle over the last 20, 30 years, or would it just be the old common law? And I think the answer is it would be the common law as enriched by convention principle. So if that dark day were ever to come, where the convention, the Human Rights Act were repealed, it would be quite an interesting thing how far you could go, as the speaker said, with common law. Yeah.
Hi, can you hear me?
Yes,
Hello.
yes.
I'm Leela. I lead race and youth justice policy at the Howard League. Thank you so much for that. It was really interesting. I wanted to ask about the kind of interaction between human rights regimes and criminal law, which I think you've both touched on a bit. But what you were saying earlier, Edward, about the Canadian Supreme Court ruling and how it was sort of saying that prisoners' rights to vote should be allowed unless it's a sort of longer sentence. And I think there's this assumption that, you know, if someone has a longer sentence, they've done something worse. But obviously criminal law is so elastic that now we're seeing, we've always seen, but now with joint enterprise and conspiracy and IPPs, people in prison on longer sentences who haven't actually done anything that bad. And I was wondering how we ensure that human rights regimes are elastic enough to track those inconsistencies in criminal law, and how we sort of use rights-based arguments to combat those injustices, if that makes sense.
Yeah. Shall I go? Yeah.
You
Well,
kick
well,
off.
I think, and I'm going to have to confess to not being totally on top of. There was a later decision of the Canadian Supreme Court, which I think extended the right to vote, but it was the earlier one that influenced the European Court's decision in the Hearst case. But yeah, you're right. I mean, the sentences, length of sentences are not necessarily a guide to how heinous your crime is, because it may depend on various sentencing regimes. I mean, look at all the unfortunate drug mules who are getting 16 years for, you know, aged 18 for taking drugs, you know, where often with an element of coercion or I mean, you know, the sentences were ridiculously high for those. But we did try Article 3 arguments and got nowhere, as it were.
Yes, we've tried modern slavery arguments too and got nowhere.
Yes. So I think, yeah, I mean,
Those sentences have come down.
Yeah. They actually, then it was a sentencing council.
The
Sentencing council had a review, but there was an argument there that now that the sentencing council has recognised that the sentences for drug mules, particularly those, you know, with, I mean, mothers with children in Africa who were being pressed into taking drugs and then getting these massive sentences, were disproportionate, that all the old ones should be reviewed, and the Court of Appeal just said no. I think so. I mean, there are massive problems with the proportionality of sentences, but the European Court's been pretty hopeless on that, on the whole. But apart from Weeks, where they sort of said giving a life sentence to a pathetic 17-year-old who goes into a sweet shop and says stick him up, and then drops his thing and drops the money and runs out and gets life as the most merciful sentence the judge could impose. They did say, well, that seems a bit steep. And it would raise questions about Article 3. But even there, they didn't say, this is frankly inhuman, you know. So I mean, I think the proportionality of sentences, the European Court has tended to say hands off. We'll leave that to the particular regimes of the particular countries. Where one has more of a chance is where it's some special status group like children, where you can argue for additional rights, or systems of preventative detention for dangerous offenders. They'll institute rights for them. But was that the kind of point you were making? Is that, yeah? I mean, it is. So I think one really falls back on old-fashioned sort of common law principles of proportionality of sentence, really, there, rather than European Convention principles.
I mean, as it happened, following Hearst number 2, and in the 12 years or whatever it took to resolve the issue, there were various proposals. It was 4 years and under. Then there was a proposal by a joint committee that said 12 months and under.
Yes.
And then there was there was 3 types of sentence. But ultimately, actually what the government agreed upon was not based on how long your sentence was. It was those who are released on temporary license.
Yeah, I mean, the government got away with murder. I'm sorry, but I mean,
No, but that's better than
yeah.
it being based upon a particular sentence. But
I see. But I mean,
do you know what I mean in
yes.
terms of an arbitrary 4 years, 12 years, whatever, 12 months.
Yeah, but yes, I see. Yes, no. Well, the government really. I mean, I think, but it's an indication of how the desire to keep the UK on board with the European Convention has led to massive concessions by the European Court. Being frank about it, you know, that's what happened with that case. That in order to keep, and I think something like that's going to happen probably with the Rule 39. That they'll say, okay, you can have a hearing beforehand, you can have an appeal. I don't know, but I think they probably will introduce reforms that satisfy the complaints of the UK.
I mean, they did get away with murder in the sense that they said released on temporary license. So anybody on indefinite, you know, IPP types, I suppose, or anybody on indefinite, like, you know, life license is obviously excluded.
I mean, I think from a human rights point of view, it's actually the prisoner's vote is quite a hard one to argue from convention. I mean, you either instinctively feel no one should be excluded from the vote, in which case it would apply across the board, or no, they've broken their contract with society, they therefore don't, which was the argument of the government, therefore they don't deserve to vote. I mean, it is a difficult one, that. And I mean, I think it's almost an article of belief. You either believe, well, prisoners should, of course they should be allowed to vote. They're human beings, they're part of society. Why should they be excluded? Why shouldn't they be integrated into society? Or you take the view of the government, which is they've broken their contract, and for as long as they're serving out their debt to society in prison, they shouldn't be allowed to vote. I mean, it's a difficult one to ground in any fundamental principle, I think, other than some article of faith about humanity and rehabilitation.
The fear that they may not vote for government of the day.
Yes, I think one of the fears was that if you had a lot of voters in some particular constituency because the prison was there, that would disproportionately affect the
it would skew the election.
The election,
yes.
Yeah. Sorry.
I think on that note, we need to wrap things up. But can I say to both Edward and Maya, on behalf of everyone here tonight and everyone online, thank you so much. It was a really fascinating conversation, really insightful. Thank you very much. If you enjoyed this evening's event, please keep an eye on our website for further events coming up in the year. Tell your friends, tell your colleagues about the HRLA, invite them, encourage them to join. And thank you again for coming. Do please stay for a drink and stay for a chat.